Hello, my name is Jay Chauhan. I am a mentor at the Angel Mentorship Group. And today, Wednesday at noon, on the 17th of November, we are going to talk about the Planning Act. And in the first portion of the discussion, we will have the theory of the Planning Act. I won't go into the specific sections. For the second portion, I will have Naman, who is used to be an Ontario active lawyer, now is practicing in New Brunswick. And he will frame the question, and I will give the answer based on the theory of the Planning Act, what was intended to do in both Ontario and New Brunswick. And then we will have the particular problems that he's dealing with dealt with in terms of the solution to the issues that are raised in those questions. So can we hear, Naman, from you? And if you can frame the story and briefly the facts, and then I'll narrate the theory and the answer.
Hi, so my name is Naman Sharma, and I'm a lawyer based in Moncton, New Brunswick. I provide services in real estate. So today, the topic is real estate. It's a practical problem that I'm facing currently. The situation is that I am representing the purchasers in this case. So the seller has died, and now the estate is going to sell the property. Now, in this situation, the particular conundrum that we face is that the estate owns two of the adjoining properties at the same time. So now, Mr. J, my question to you is, if the seller owns two of the adjoining properties, what will be the role of sellers and purchasers lawyer in such a transaction? How will they proceed with the transaction?
I think let me redefine the question for the group and for me to present the theory of the law that we learn in the school in the real estate law. Firstly, in terms of the common law, what happens is that in the common law system, unlike the civil law system, the question to you as a purchaser lawyer will be framed in terms of what you think about the title in your own mind, because you're responsible to your client in terms of providing the reporting letter and saying to the client that I went to the solution of the problem in real estate and I found the Planning Act issue and I found the following solution. So I think first of all, it's important to recognize that the way the legal regime in Ontario works, and New Brunswick actually works also in the same fashion, namely the purchaser solicitor will create the investigation of the title. And then after the title has been determined and the vendor's role established in terms of what he should provide to you, that you get the answer. And I will divide the two answers in terms of the theory first and the practice next in my response to you. So let me just go through the theory of the legal system and regime itself. So the Planning Act was introduced in Ontario some decades ago. And I think I saw from talking to you that it is very similar in New Brunswick, actually. The purpose of the Planning Act is to plan the living of the suburban living, the industrial areas of the municipality and other areas so that the living is tidy, neat, and clean. If you see that actually in some countries, you would have cows walking on the street there, and the village in terms of the residents and the industrial activities all mixed up together. But I think to try to separate these areas of work and living was done very, how shall I say, much in the Planning Act, in which the objective of the Planning Act is the following, that you want to create a scenario where the ownership of the property and the division of the land is not done in a haphazard fashion as it is done in some countries. So in other words, you can't have a situation where you're living there, you have a road, you have the other conditions of facilities, utilities all built up and provided the electricity, the gas to the house, and the sewage system connecting with the house. And so these are all easements and existing law utilized to create the communities which are more, so to speak, organized actually. So how does it do it? There are two broad ways in which this is organized actually. So I think this is not mentioned incidentally in the admission notes actually, that why is the Planning Act there in the first place? But what is there is the responsibility of the lawyer in the Planning Act. So what it did, instead of saying that, okay, well, let's just organize the municipality through the bylaw system. So there's a municipal act, which is provincial. The municipal act authorizes and gives the authority to each municipality to try to allow the municipality to create bylaws which have the enforceable ability to regulate the regime of the way in which the communities are organized. So the first part of the organization is that when a developer comes up and says that I will develop the idea that this area where I am living, for example, was a golf course, and then it was changed into subdivision. So the developer then comes up with a plan of subdivision and takes one lot, which is described. I won't go up today into the description system. We'll have a separate lecture on that subject, but description of the property is done by lot and plan. So the plan is an area on a survey that covers a certain amount of property, and it is described by a description called meets and bounds, through which you will present a plan which is drawn up by an architect, or there are people who actually go to the municipality, read the bylaws and know what to say, and the municipality then goes through various different parts of the system of the municipality to try and approve the application for subdivision. So in different words, there is a subdivision which shows a number of lots, the roads, etc. So a lot and a plan number, which is registered on the title, which is sitting in the registry office, now in the TerraView system on your computer, will describe the property which you're subdividing. So there'll be a map, properties exact, the lines drawn with the meets and bounds description. Just for those who don't know, it's not in the admission notes either, that the meets and bounds description of the property is done by a compass system, actually. So the compass starts at a certain location, it goes certain distance and turns at an angle, and then it goes from north to south to east to north and west again. So you come to the original point of description. That description is then shown on a sketch, which is given to municipality, and then the municipality then, after going through asking the questions through the system of presenting the plan and how you provide the services, roads, and etc., then the municipality will approve. If you have an approved plan of subdivision, it'll be put on the title, and it now subdivides the land in which you have the authority to convey each lot separately, which otherwise would be breach of Planning Act. Now, to impose the duty of who should administer the Planning Act, the duty to check that is properly complied with was imposed first on the municipality that will approve through the planning process, the whole process of creating a subdivision, and then allowing the builder who comes up with a plan that I will buy the land, divide the land, and make a lot of money out of it. You have conditions set by the municipality as to how they can do it. Just to make sure that you comply, the municipality will use the end of the road to join the main road by an easement, which is not released until the end of your compliance. And in a 2 or 3 year period where you build all the properties and say to municipality, I've done my job, you give me the release, and they give the release. So there are lots of exchange of information between the municipality and the builder to create the plan of subdivision. So that's the reason for the Planning Act. But what our role as lawyers is in the real estate, if you do not comply with the Planning Act provisions, the conveyance is declared to be void, which means that you go through all the registration process and put your property on the title and say that A sold the property to B, but B never got the property, even if the deed was put on the title, because you didn't comply with the Planning Act. So subdivision of the property for which there was a reason, that reason is never explained in the admission notes. So you have a challenge in your mind trying to figure out what should I do in the title point of view, which I'm going to address, Naman, in a minute. But that's the one way in which you subdivide the property. So you have to look for a plan of subdivision, properly registered. And the second method is that if you have a countryside property, which is not a plan of subdivision, because you might have a farm, and the farm has 2 properties. So in New Brunswick, it is not as densely populated. So you have a situation, in your situation, there is a person who owns 2 adjoining properties. So this might have been done before the Planning Act came into force, so that phasing in of the Planning Act in your jurisdiction would have to take time. So he's maybe one of the people in which he may have not had the opportunity to subdivide the property. So another method of dividing the property is getting the consent of municipality through an arrangement called Committee of Adjustments, actually. This committee is made up of civilians in the municipality who actually are people who are semi-politically inclined. They're very often form a part of the committee. They are lay people, they're not lawyers, they're just citizens of the municipality, and they approve by the consent they give to the authority of the municipality, the approval for a subdividing of the property. So that is a process in which the municipality opens up the door to other people, especially the neighbors, and gives the notice and said, we plan to subdivide this particular property. Do you agree? So that takes a time, actually. So the time is then lost in terms of the day. The builder is counting the day because he's borrowed the money, he's got the land, he bought it, now building on that property, and then you're looking as a builder to get the consent of the municipality to have what is called the consent of the committee, which then also legitimizes the conveyance. So if you got the Committee of Adjustments consent, and then he gives it the property to the purchaser, and the purchaser lawyer like you, Naman, is giving the survey of title, then you have a good title to the property, and you then write a report to the client and say to him that you have a good title. And I think we've done another seminar in which we have explained actually that how do you show to the client that you've got a good title and what is your responsibility as a lawyer. So having explained the theory of the Committee of Adjustments and explaining the theory of the subdivision, I just want to address, Naman, the question that you were addressing. Now, within the framework of this law, how do you solve the problem? So first question, actually, just to reframe the question is that when you get the title from the vendor and his solicitor, and to say that I will be conveying this property to you, your client, what do you do? So the answer to that question is that using those categories of the bylaws, you have to tell him, which I mentioned to you earlier, is in your so-called requisition letter, which we write to say that I've searched the title, I see that the two properties are together, I require that you provide the subdivision of this property with the Committee of Adjustments, but you don't have to write that. You simply say that I want you to obtain the consent of the municipality, and then when this consent is obtained, please send me the copy of the letter. So you fulfilled your mandate in terms of what you should do to shift the onus from you as the lawyer of the purchaser to the vendor as the lawyer. And I think that requisition letter should contain a paragraph that simply asks the vendor lawyer to fulfill the requirements of subdivision, the Committee of Adjustments, or any other method that the local jurisdiction allows to allow the subdivision to take place. So I described to you that there are some citizens committees, the public is invited, etc. So I think you mentioned to me earlier, not in this today, but earlier, that you had given about 15 days. So it is my view that in the New Brunswick, the process does not take as long. If it is Ontario, the process takes very long. I have a client situation myself where the person waiting for a long time for the committee to give their consent, he lost a large amount of money, and he is really in a difficult situation, becomes a legal issue at that time. So I think, just summarizing, your requisition letter is the number one item that you do to the vendor's lawyer. The vendor's lawyer goes to municipality, obtains it. It is very important in my view, that when you obtain a copy of that letter from the municipality, use your own understanding of the law to ensure that there is compliance with the Planning Act, so that the conveyance is, so to speak, legitimate and a proper conveyance. Otherwise, your certificate of title in your reporting letter to client is incorrect and can create liability. So I think so. That's number one. Number two, when you get the answer back, he says, okay, so there is the law of tender that says that you must close on the day in which you schedule the closing. There's also not in the Barmation notes that you ask the vendor lawyer, how long will you need to obtain the consent? He says to you that 2 weeks. So you said, okay, you extend it for 2 weeks, and you sit back and watch him do it. So when he's ready, a few days before the 2 weeks expire, you see the letter, study it, and make sure that he has complied with the subdivision arrangement to the Committee of Adjustments and obtain a separation of the two properties because they're two houses, and he will draw the line. He will, if the survey was not done before, here's my comment to you, Naman, as well, that you should ask for a survey also in your acquisition and say that, let me have a copy of the survey, because the subdivision, the Committee of Legal Adjustments may not have a proper survey if the formalities of conveyance or the separation of properties is not formalized in your province, actually. So when you have the proper survey in a concerned municipality, you have a good title under the Planning Act. And then when you report to the client, which is the purchaser lawyer reporting to client, you have to shift the responsibility to firstly the vendor solicitor and say that relying on his letter in your reporting, you're saying to the client that relying on the letter of the vendor and a copy of the consent of the Committee of Adjustments, my opinion is that you would have a title of the property. But the other thing that has happened in the last few years, or rather a couple of decades, is also the insurance companies have come up that to say that the concept came from US actually, basically that, okay, when a lawyer is busy trying to give a title report to the client, what is he supposed to do? So they took the responsibility away from the lawyer and said, we will certify the title. So second recommendation that I have for you is that you ask the company insuring the title to the property that they will take the risk and that this is the impediment that you saw in the title, and do they approve? So as soon as you get the approval from your title insurance company, they will insure the title. And therefore, you have done two steps to remove the responsibility from you to firstly the vendor solicitor, as well as the insurance company that certifies the title and insures the title, not certifies. You is the person certifying the title. So you withdraw your responsibility and say in the reporting letter to the client that based on the insurance, based on the vendor solicitor's recommendation or report that he has obtained the consent, you reporting to the client that he would have, you don't have to write that sentence there also, by the way. So I would recommend to all the lawyers in all the real estate transactions that we learn to report to the client without the traditional historical way in which the purchaser lawyer in common law jurisdictions have asked the lawyer to certify the title. And this is continued in Ontario to the mortgage companies that insist on their wording. And the reason why they insist is because they want you to be responsible. And with the lots of money the banks carry as mortgage companies, mortgagees, they don't want to take the responsibility. So they're shifting it to you. So our battle as lawyers is to conform with the Planning Act. And the weight of the law was put on our shoulders to then make sure that the title is proper, the conveyance is proper, the procedures are properly done. Otherwise, all the certificate of the conveyance that you report to the client will be inadequate and that you could be negligent. So the two areas of concern: the diligence of the purchaser lawyer, which should be all the sequence that I mentioned to you, namely the insurance company and the vendor solicitor's severance of the property, the Committee of Adjustments, and then reporting correctly to the client. So I just want to make a comment on how the negligence should be dealt with in every file that you handle. And why I didn't have a history of negligence in my decades of practice is because I address the question, and all the lawyers, Naman, are busy trying to develop practice. You mentioned how many closings each lawyer is doing in your town, and 150 transactions. You can make real money out of that, actually. But I think making the real money, you don't want a situation where you're found negligent. So it's better to slow down. And if other lawyers are making 150 deals a month, you make it 100, it's okay, because you don't want a headache, because when it goes wrong, because you didn't comply with the rules or a Planning Act, then the worry that we go through as professionals is really out of proportion. So that's my suggestion in the answer. So I'm more or less finished answering the question. And I think a number of other issues arose out of it, which would address in separate seminar, namely, how to use the description of the property, which is not also in the admission notes, actually. Meets and bound description, how do you create the description? How does the PIN number work? How does TARA view work? And how does reporting and insurance work in the title? So that's my answer, Naman. So hopefully that was helpful. And any other questions arising from the group, I'm happy to answer them now.
Jay, I have a question
Yes,
regarding this. In Toronto, when the property, of course, all the property, most of the 99% is in a land titles now.
yeah,
Now the land titles, the plan called M plan. Okay. Now, for example, I'm just using just imaginary number of plan 1450, and there are two houses built on that plan. On that, well, there's one particular lot, which is lot 6, for example. There are two houses built on that lot, and so the two lots which is not subdivided, the two houses which is on particular plan, lot 6, which is not subdivided plan. So in this kind of situation, how the planning act works, because I have seen recently somebody asked me the adjoining house is owned by the same person. So we have to, if there is only if there is a reference plan has been registered, which is a further subdivision of that plan.
mhm.
So how it works exactly, means,
So
my question,
yeah,
sorry,
carry on.
the two houses adjoining house owned by the one person, and one of the person, the purchaser want to buy one of the house. So the vendor has to comply with the planning act. So what's the answer for this kind of situation?
So let me address the question of Land Titles Act first of all. Actually, since you know that as Canada was being settled, actually, the registry system, which is a recording system of who is the current owner, and certifying title by 40 years chain of title being correct, was the traditional method of certifying title by the purchaser lawyer to his client. In the land titles regime that was originally created in England for Australia, actually, which was brought to Canada, was to create a system by which this 40-year title search to be certifying good title to the client was improved by creating a system by which a fund was created in the land title regime, so that if the registrar of title said to you that this is the owner and you relied on it, then if there was a problem, the registrar of titles then would compensate you. That's the regime of land title system, which is different than the registry system. So all registry offices had two separate counters in Ontario, actually, until recent years, actually, which is one for land titles and one for registry system, actually, because the conveyance was done very differently in each one. So, but anyway, I think when in a planning act situation where the two properties are the vendor's name, and you conveyed the property, the owners were shifted from this pool of money put in the land title system to the lawyer's shoulders. So he was asked that if you comply and waiting for the fund to compensate you for the wrong title is no good, because you could be responsible with your personal insurance of the low pro, and you could be liable for the negligent kind of conveyance you allowed to happen for your client. So I would not rely on the land title system to compensate the lawyer in this situation, actually. But as far as two owners, two people owning the same property, if you look at the wording of the Planning Act, you will see that the wording is such that I can't remember the exact words, but the Planning Act wording says the conveyance is deficient if it did not comply with the severance. So as a result of the wording in the Planning Act, anytime a vendor has two properties, then it has the effect of merging the two properties, because one person, like a farm situation that I described before, would own the two properties and one of them only is to be conveyed. So the way to deal with it, including Naman's situation where the state has taken over, is the following. The purchaser lawyer should requisition the vendor lawyer and ask the vendor lawyer to sever the property, regardless of land title situation or registry system, and shift the owners to the vendor's lawyer, because it's his right, obligation to convey the title in the common law system. So when he separates the property, then you get the good title, land titles or registry system property, then you have a good conveyance to the property. But I would just want to say a couple of words for the question of Naman, actually, which I forgot to mention, is that if the vendor owned the property and the probate system has not been completed so that the executive of the state is in a position to deal with the issue, then you have to obtain the probate first of all to convey the title. So I think I want to just tell Naman actually that one of the problems and challenges might be that when the vendor has two properties, but the vendor has died and the probate has not been obtained, it can create a challenge for the purchaser lawyer, because the only time that in a probate situation when a person dies that you can really convey is the executive estate as approved by the court, surrogate court. So therefore, I think in addition, Naman, to requisition for good title, you should ask the vendor that he has the authority to convey the property. So when you write on the register actually that you've done a conveyance, there will be a box there in the Terra view that will say that yes, this is an executor for the deceased estate. So just one suggestion, Naman, for his question is this understanding, which is not in the bioadmission notes, which is to understand that when a person dies, what happens to the estate? The estate survives the death of a person. And who is the person that can deal with it? The deceased person cannot deal with the property. The legal regime actually is a blank, actually, between the date of the death and the date on which the probate is issued to the executor. Between these two dates, if you did any act, the issue of probate retroactively works to convey the decision of the vendor when the probate is issued. So, but I think you, as a purchaser lawyer, you should not take that gamble actually in a estate situation. So my view is that you should look at the probate itself and then say, okay, you have the authority, and you may write on the Terra view system or whatever the system is in New Brunswick, the fact that you have the authority given by the surrogate court, now is a different name, by the way, will have the authority to convey the title. So that's my answer to both Chaitanya and to Naman.
Okay.
Any other follow-up questions? So if not, then I'm going to stop the recording.